accept the similar petition, you are considering the sentiments of the people, whereas if you are not rejecting it, you are focusing more on growth. So how do you ensure an equilibrium between the two?
So growth in terms of reduced litigation cost?
No, in terms of overall development of the country, like if you are acquiring the land for some public purposes, like building of roads, highways, or anything.
So say these costs, litigation expenses and compensation cost, they are incurred always. It's just that they are incurred by different government, right? Other thing I forgot to mention, Mr. Pandey had mentioned about Noida. So what happens is that when court increases compensation, if you own property in Gurgaon, in Haryana, in one of Haryana cities, you will get a bill. In Noida, developers will get a bill. Government will say that court has increased compensation and therefore land cost has gone up, so you need to contribute towards that. This also means that there is an incentive for government, for officials to defer, to make law offer, so that tomorrow somebody else will bear the consequences. As a society, we are having to bear the consequences, right? We are having to bear the compensation cost. It's just that the political dynamics make it incentive compatible for incumbent government to defer these costs.
So sir, I'm not talking about compensation, I'm talking about not acquiring the land itself. Because I have sentiments attached to it, or I have certain personal reasons for which I'm not willing to sell my land for any cost. So in that case, I have some sentiments, and
yes,
the government has a reason to acquire because they want it for development.
Yes.
So
now,
how do you ensure an equilibrium between them?
There is no equilibrium if your sentiments are compoundable, as lawyers will say. If you can put value, money value on your sentiments, then we can ask a question, is project still worth it?
Yes.
But if you are extremely sentimental about your property, you say over my dead body, then that land cannot be taken away for any project, right? So we have to say that this much of sentimentality is okay. What are going to be social gains? Some exercise will be, it will not fully solve the problem, and problem cannot be fully solved, but it makes some progress in that direction. It also says that these projects are public purpose projects and those others are not. Yeah, yes.
Sir, what you previously mentioned, that if the court awards a higher compensation to the landowner, then even the private party will contribute. So don't you think this is a very good incentive for the government to actually give low compensation initially, so that it can make sure that the costs of higher compensation which are due to the farmer are then transferred to the private party? Because if at the end of the day the private party is eventually going to gain so much by the development of the entire real estate project, then they might as well contribute towards the compensation. So even if the three parties now, after the landowner has taken up the litigation, but has gotten a positive award because of what is the offer, don't you think it's a good incentive to the government to actually maintain the status quo and award the low compensation?
It is good for governments in their own interest. It is not in social interest. It is not in social interest because if people are forced to litigate, then courts have to spend time adjudicating these matters, these disputes that could have been avoided, that is social waste, and these people are forced to incur litigation cost. There are some gains, of course, to lawyers, they get more business, but overall it's difficult to say that it's in social interest. Also, it's misleading. When Noida authority or in Gurgaon, Huda, when they allotted plots to property owners, to house owners, they did not, they had in fine prints, this was also mentioned that if these costs, if compensation cost goes up, then you will get additional bill. But this is in the fine print of the contract. So governments are not upfront about this. So it's kind of game of misleading people and authorities into this vicious cycle.
So, like say in US we see that the Bill of Rights specifically says that whenever the eminent domain power is to be used, the requirements of public purpose and just compensation must be complied with. In UK, although there is no constitution, but whatever act through which but whatever acts they pass for acquisition of land, those acts specifically mention these requirements of public purpose and just compensation. So, when you said that the 44th Amendment in India did the right thing by doing away with the fundamental right of property, can you please justify that in light of what happens today?
So, did I say right thing? I don't know if I said right thing, but I would like to say that it was perhaps the right thing to do. So that time the issue was some states were genuinely trying to undertake land reforms, take away land from landlords, big landlords, jamidars, and give that land to distribute that land among landless people. West Bengal emerged as a leader in that process. When right to property was fundamental right, it was coming, the land reform, it was hurting land reforms in two ways. It was if government violates a right that is fundamental right, first of all the violations have to be minimized. There was pressure, you could always approach civil high court or even Supreme Court and say that government is being unfair, government should be stopped, issue an injunction against this violation of fundamental right. So many governments, many initiatives of state governments suffered on that count. Two, even if state government was able to argue that yes, it is violation, but we are justified in taking away this much property, still it was fundamental right, the compensation had to be substantially large. The just compensation could mean anything. It could, today it has come to mean market value compensation, but for a fundamental right, market value compensation might not be taken as a just compensation. If you are violating a fundamental right, the compensation should be commensurate with the how deep you are cutting into so essential a right. By that amendment, it helped government. First of all, it was not fundamental right, and therefore you could not stop states who were keen to do land reforms in doing that. Moreover, even when compensation was to be paid, the compensation burden came down on the state, the fiscal burden. So states that wanted to do land reforms, it helped them. Unfortunately, Indian polity, partly because of corruption, partly because of misaligned corruption, they misuse this power to go for excessive acquisition of land. The state governments have acquired land to build swimming pool for 5-star hotels, to build compressor plants for air conditioners. So public purpose had nothing to do with the kind of activities for which they were acquiring land. So it came to hurt us from, state governments went too far, but it was helpful in land reforms.
Will you agree that the objective with which 44th Amendment was brought, although that objective, if we look at the amendment from the perspective of that objective, it may look justified, but sir, the amendment in the present day, it is hurting the poor masses of India.
So that's tragedy. Now the same thing, same change that was made with the intent to benefit poor. Poor will benefit, you will take away land from jamidars, will give it to poor. So that's the same. So now as long as the direction, it depends on which way your sword is cutting. It's a double-edged sword, it cuts both ways. As long as it was directed towards landlords, the same amendment was good. But now because of political economic considerations, the powerful in our country, people who, rich corporations, rich individuals, they have come to use two-edged sword against poor. Now it is the small farmer, poor people who have become victim of that same amendment. Now the target is, you take away land that belongs to small farmers, poor farmers, people who, and in the process they get hurt, and other people who are dependent also get hurt by the same amendment.
So should that objective, should the politicians should not have applied some other creative?
But notice that, if Indian polity was upright and if they used it for genuine public purpose, it would have been good thing. You would not have seen so much of noise against against, there were abuses of land acquisition, eminent domain rights. Those abuses, and on top of that inadequate compensation. The two compound. In urban areas, people still have recourse to judiciary to try to get their due. In rural areas, farmers have no way but to go to straight to protest. But if your state was, if your state was upright and it was acquiring land only for genuine purposes, you would not face this problem. You decide, yes.
So, if I go by the statement that this whole act has a pro-farmer and a welfare outcome.
The new act.
The new act.
Yes.
Then is it, would it be better if we, in deciding the circle rate, if we take into consideration the level of, I'm talking about especially agricultural land, if we take into consideration their income or their wealth into consideration, so that the farmer, because they have debts, they have a lot of burden associated with that land.
Yes.
So, will it be more beneficial if we take that into consideration?
My feeling is that, my opinion is, unless you need to build a road, hospital, a university, you should never force people to sell their property, be it agricultural land, be it house. Do not force them. If a private entity, a builder wants to build a housing complex, let them buy it directly. If a farmer is too attached to their property, their house, they will refuse to sell. And it will not necessarily hurt Indian economy, because industrial projects, housing projects, they don't have to be large projects. If a project cannot be built here, it can be taken elsewhere. It's not like road. The roads have fixed alignments. Railway networks, irrigation, these projects have fixed alignment. You can't shift road from here to there, right? There is a justification for forcing people to surrender their property for such projects which serve public purpose and which cannot be easily relocated. But you see the Tata's project, they wanted to set it up in West Bengal and they took it to the other extreme, from East India to West India. So industrial projects have this flexibility. So let them exploit them. So do not force people to surrender land for private projects.
So if there is, if private,
Yeah.
it's associated. I mean, the question is, so if private entities take land, then it would be, will a forum be beneficial or a grievance redressal forum for the agricultural people would be a better way to look at. I mean, if
You mean collective bargaining?
where they could help them to assess their income, wealth, and all these considerations, all these financial considerations taken into.
Notice, if you are not being forced, you will demand a price that will take care of your future. You will demand a price that will at least be as good as you possessing continuing cultivation on this land, isn't it? Unless you are forced in directly or indirectly. So, but there is a role for collective bargaining. Through collective bargaining, the arm twisting by corporations, there are the big guys, deep pocket individuals and corporations. They have numerous ways of making your life difficult. So suppose you don't sell your land, and if I am able to buy land of your neighbors, I can start discharging pollutant on your land, make too much noise or spew out too much dust or smoke, so that cultivation becomes unprofitable and you are forced to surrender your land. There are numerous ways individual farmers can be, or individual property owners can be arm twisted in selling their property. So therefore, there is a role for collective negotiations also, so that individuals do not get arm twisted. Yes, you had a.
Don't you think that in the light of 2014 land bill, the condition that 80% of the farmers must agree during the land acquisition for a idea of politics to prevent private from doing it, the politics of rights. So because practically even in a family, never 80% of people agree to give land.
You are absolutely right. So, but let me give you few illustrations. I can, in this EPW article of mine, I have cited some instances where hundreds of acres have been sold in contiguity by farmers. So, private corporations, firms have been able to buy hundreds of acres, not wherever they wanted, but they have been able to buy at some places. The point I want to make is that it is not impossible to buy land in contiguity in small sizes. Other illustration I want to give, you think of any major brand, be it McDonald's, be it, think of 4, 5, in some cases 10, 11, 20. So, they have their own smart ways. Just imagine if Reliance or McDonald's, if they are able to buy land in contiguity from several people in thick of city, it is only easier if you go to remote areas. So, life will not be easy for them, but life also will not be impossible for them. You can already see they on their own they are doing this. So, it just we need to create incentives so that they directly negotiate with the property owners rather than using state authority to force people to surrender their property.
So if I'm not wrong, doesn't it imply that leave me alone principle, which was called by capitalism?
As such, well, capitalism has several problems, and this is one of the principles used by capitalism. But as there is no, as long as you do not block a genuinely public project like irrigation, road. So, I would like to vote for leaving you alone. We are not isolating you. It's not that you will be subject to quarantine. You can sell your property, but I am not for forcing.
Sir, my next question is also from the 54th amendment. So that amendment introduced one more thing which is generally overlooked, and which is that when the parliament was doing away with Article 31, what it did was it introduced as the second proviso of 31A one thing, and that was that when a piece of land, when a farmer holds personal cultivable rights to a piece of land, then he will get the full market value in case of acquisition by the state. So, do you think that this right to personal cultivation
Yes.
is more valuable than the right to reside, or the right to get it cultivated by some other person in case I am?
Yes, I am glad you asked this question. So, let me lay out this issue. Imagine, so in West Bengal, farmers, people who do the farming are not necessarily owners. That is true in many parts of the country. In many villages, there is a large number of cultivators who are not owners. However, in West Bengal, through land reforms, tenancy reforms, the tillers were given formal rights. It was like contractual arrangement between, they had legal right over land, not ownership, but some formal legal claim over that land. That established that this tiller cultivates this particular land. There was formal legally recognized relationship. Similar relationship can be there between a landlord and a tenant. If they have signed a contract, what do you call that? Rent contract. So, lease or land contract. So, now think of two scenarios. Scenario like West Bengal, where there is legally recognized right of a cultivator who is not owner. If this property gets, if this such land gets acquired, then property owner, absentee landlord, and this tiller, they both have right to compensation to different degree, but they both have legal rights, or they both get affected and they both have a claim. In West India, I know for sure, Haryana, Punjab, these rights are not, people do not sign formal agreement, landlord and tillers do not sign formal agreements. So, if land gets acquired in western or remaining parts of India, then same tillers will get nothing by way of compensation under the old law. New law has rectified that problem to an extent. So if you can show that for 3 years you were cultivating here, you become entitled to compensation. So it has been remedied, that problem, to an extent. But under the old law, yes, that was a bizarre situation. Depending on whether you had a formal proof to show or not, you could be entitled to some compensation or absolutely nothing. Same logic applies to property owners versus their tenants. If there is a legally registered rent agreement between you and your tenant, and your property gets acquired, then that person, you can also claim now, your logic will, before court, you could argue that your compensation has to be compensation for this property, land, for its superstructure, and also because this land acquisition has led to my reneging of contract with my tenant. You agreed to provide accommodation for 1 year, for 2 years, you cannot do that now. Your tenant has a case against you because you are in violation of that agreement, but that's not your fault. State made force that violation. So state should bear the consequence of that. That means to say that you can claim compensation for violation of that contractual obligation that arises because of this land acquisition. But if there is no formal agreement, there will be no formal claim. So it was on account of these technicalities that very few people benefited, large number did not. Today, under the new law, more people will be able to benefit.
The definition of the property, the land acquisition and the transfer of property is quite different. The definition of the property is that even you possess the property without having a title of it, even that you are to be compensated. This has changed the entire connotation.
That's right. So the entitlement to compensation.
This entitlement to compensation, if you are facing consequences merely by any provision. How
That's right.
I understand wishing to adding to that thoughts is stuck in your mind, fundamental right to
It is also written in BD1.
But those were genuine at that time. Government had genuine, I mean, there was a genuine case. But problem with corrupt societies is,
I'll give you one example. There is a temple in a roadside. Temple is being built and worshipped by many people. Now the road is supposed to be widen out. And people are having a religious faith. They are watching their religion for 100 years. Now how if government wants to acquire that piece of land, what to do? They have demolished the temple because that the religious faith has demolished. So, if fundamental right to property is a fundamental right, and then there is no problem who cannot take it that religious faith and all those things.
if it is a fundamental right. So a quick aside, these days you will find at several places, gods are being deputed to protect your property rights, especially in cities at corners. So you will find there is a chain of small structures. They essentially are, those are gods, but who are who are guarding your property. If you had proper fundamental right, you won't need gods to protect your property. You need gods to protect your property because it is not a fundamental right. But it's Indian ingenuity to achieve same outcome through gods.
We have faced this kind of argument because I was a high custody in that matter in Bangkok. We have demolished roughly 500 temples in acquired land.
Where?
At the Madhya Jabalpur. It was a huge area.
Was it a BJP government?
Yes, it was a BJP.
It had to be.
BJP Congress vote.
Our paradox is, it got to be BJP government. It's easy to infer. So it's true that gods are being misused to to safe to protect your property. You put one tiny structure and nobody can dare touch it. Who can dare touch this? By the way, these are difficult issues. Who can dare to touch this? Any government, so you can touch your own God. If you have proven credentials as, pro-Hindu, then you can touch Hindu gods, because people will not, raise slogans and say that you are anti-Hindu, you are this or that. So it had to be BJP government in Gujarat to make a beginning. And I must say these were right kind of things that were done. When gods, instead of human beings, when gods were rehabilitated from one place to other. So, but not any chief minister, not any government. It had to be some type of people, who can. After all, it's if you have some proven credentials for something, you can do more things on that front. So, if you are pro-farmer, if you are known as pro-farmer, you can talk about taxing agricultural land. But if you are so you are known as a pro-business, you dare talk about taxing rich farmers, they will you had it. These are all political economy considerations. So.
Second difficulty which we face in the court also, in filing civil writ petitions and you see, many fundamental rights were not there in the constitution, and they came by way of it. Right to life is extended as many ways, freedom of speech is extended. Suppose, therefore, we say the only property right is not in a fundamental right, it's a constitutional right. But I am being affected by because my right is not in my house. So it is a right to life. It is a right to life. My right to life is being affected, and you cannot do it. So in that way, the consequential effect which was there, you are putting by way of interpretation fundamental. So there was an argument that the court was declining for the simple effect. If by way of interpreting it in this way, then the fundamental right is a kind of a thing which is a contract with the government, sort of a contract with the government. That you surrender your all rights, and this much is assured, and that this much cannot be sacrificed. Any restriction has to be utterly reasonable restriction. The degree of wrongness is not there. It has to be that. So even court are declined from interpreting the consequentialities of this acquisition to connect with any part of the article of the constitution. So this is how court thinks, and this is how we think. Because once we interpret any remote part of it, so then there is a problem.
The courts will also face the problem, how do you decide compensation if you admit it as a fundamental right? And they have no answer. At least market, howsoever ridiculous, but they know how to go about doing that. Government use stamp duty rates, circle rates, they use sale deeds. If you admit it as a fundamental right, and you take away something that is protected as fundamental right, how do you compensate for that?
The court said that we provide just compensation, and about just compensation.
No, it can't be just compensation for fundamental right.
Sir, about right to property, it was written in Article 31 that these two requirements were there about public purpose and just compensation. And
I meant to say the market value cannot qualify as a just compensation for a fundamental right. For a legal right, market value may qualify, may pass muster as just compensation. Just has to be incommensurate with severity of right that has been violated. What kind of right you have violated and how deep you have cut into that right.
Sir, that is something which is to be decided by the policy of the state in commensurate with the economic policy.
Lawmakers, yes.
So the policy consideration in the judicial review has an extremely limited interference, and this is something which is to be decided by the executive.
I would say by legislation.
By legislation. So market value, just compensation, these are words eventually will fall in some sort of an executive order, and then it can be challenged in civil cases, not in civil.
Yes. You don't need provisions for, yes, answer is there is some, this 70%, 80% conditions. So, they indirectly it means voluntary transactions. The consent has to be voluntary, but you don't need any provisioning for this. You are always, any property owner is free to dispose, sell, destroy their property as long as it doesn't hurt others. That's the yes.
Yes.
All right.
I have this one question on are courts the best place to handle compensation cases? This is a lot of
Oh, yes. Yes, because of the reasons I said that, the courts, courts do not have agenda like state. State has agenda to reduce fiscal burden today, to defer burden onto the next government. Courts do not have that agenda. So, on that count, courts can do better job, and they have been doing better job. That is so clear. No, answer is also no, because courts do not have all the information that is needed. Travesty of our system is district magistrates, deputy commissioner's office has all the information that is needed to assess market value. What is the information that is needed? Voluntary sale transactions. Who has this information? Courts do not have this information. Property owners, acquisition affected owners also don't have this information. But registrar's office has all the information. Problem is that they have all the information, they don't use it. And courts do not have this information, but they have to use this. So, ideally, in an ideal world, it's the ADC's office, district magistrate's office that has all the information, they should decide on compensation. But given their other incentives, they are not expected to do a fair job of that's why the courts. Yes.
So what we have learned today, so some things feel that it's too hard for private sectors and some are too hard for farmers. So is there a middle path, like for example in China, those are very hard, but there is a system that if a land is taken, then the people are rehabilitated on the, I think on the cost of government, and equal amount of land is given or to the price value. So can there be any solution or any such step taken to take a moderate step?
You are right. No, trade-offs like if you give powers to government to acquire land whenever they want, they will do what they have been doing. That was a problematic scenario. There is no doubt about that. If you make land acquisition impossible for private projects, there are some genuinely good projects that need to be promoted, but some of those projects will get adversely affected. So there is no easy way out here. So we have to strike a balance, and in my opinion, you don't need government to engineer, facilitate land for land deal. Suppose you have a good project, you want to launch project near Kanpur. You yourself, if you give lucrative price to farmers, farmers also know that if I get good price for my land, I can sell this land and I can buy land for cultivation in more remote regions or elsewhere. So you don't need government to facilitate, to arbitrate this land for land deal. Private parties, farmers themselves can do it, private parties can also do it. In my opinion, what you need to do to facilitate life of project developers, you need to make land titles clear. Today, the way many projects, genuine projects suffer is because the land titles are not clear, in the sense that you don't know, just because you see somebody is cultivating or residing in a house, you don't know whether you are talking to a real owner or not. People who have possession and people who claim ownership and who are actual owners, in many cases they are different set of people. So, who do you talk to? If your land titles are clear, then you know who to talk to. So, that can go in long way in helping in mitigating the problem. The other reason why our industrialist project developers they want land acquisition is that for to be able to set up a factory, a housing project, this is something you want to pay attention. This is, I don't know, I don't think this is readable. You can read these things online. So, for every project, our industrialists and developers, they need to get what is called land use certificate, change in land use certificate, which is a sheer source of corruption. You cannot build an industry, you cannot build a housing project without getting CLU. It is a big source of corruption, big source of big money for politicians, for governments. So much so that cost of this certificate comes out to be as much as 1/4 of total project cost. So, and it's possible to get rid of this problem. Rather than asking for CLUs, change in land, you go for zoning. You say that this land is open to setting up industries or for housing projects. No permit is needed to set up a factory here or to set up a residential complex here. So, these steps also can motivate project developers, can ease up their life. Suppose you are a farmer and through zoning regulation I tell you that this land is open for industrial or for housing project. As a farmer, unless you have special type of sentimentality, you will be very happy, because today if you sell your land without CLU, nobody can build house on that land. But under zoning, a farmer will be happy because straight away house or industries can be set up and his land will command higher price. So, farmers will be happy sellers and buyers will be happy buyers because they do not have to pay these charges.
So, thank you. Quite honestly. So, in Karnataka, I was dealing with the same application. The law clearly says that within 6 weeks of making a CLU application, if the application is complete and we don't obtain permission is deemed to be a So, I don't think CLU is, at least in Karnataka, it's not a major problem.
It used to be a major problem in Karnataka too. In some states, Gujarat has made some progress on this. More recently, Haryana also has. Some states have started to streamline their regimes.
Zoning, I think will achieve the same purpose, because even in zoning, you can't have this static sort of distribution that this is perpetually agriculture or this is perpetually. So even in that zoning, you need conversion.
The two have been treated as alternatives, either this or that. If you have zoning, then you are granting automatic approval. If you declare something as a residential area, you are granting automatic approval. The CLUs are needed for land that does not fall in that zone. So, deliberately state governments did not want to use zoning because zoning was not source of money, CLUs were.
So, whatever we have talked, can I make a hypothesis out of it that the best thing that the government can do is to minimize paperwork, which implies de-bureaucratization and which implies that government should allow to reduce the transaction cost so as to apply post theory.
Government should reduce transaction cost, government should reduce regulatory burden on land.
Yes sir, de-bureaucratization. Deregulation.
Well, something or different zoning regulation would be my answer.
Okay sir.
Yes, I agree, that's a fair summary, I would say.
And so sir, on the crux of the matter, only means that we must allow the people involved to work freely and reduce the transaction costs.
Right, that's right. Except for genuine public purpose projects.
Yeah sir, that's something government has done.
Yes, that's right. All right.
So can we do away with the power of the state?
No, then how will you build your roads? How will you upgrade your roads? How will you carry on with irrigation projects, railways, ports, airports, there are genuine justifications for this.
So should it only be used when land is to be, I mean, when contiguous pieces of land is to be acquired?
That's
Or-
right. In any case, so the case for eminent domain is based on contiguity. Even for, what's your name? Anshul. So he was, uncomfortable with my position, you could sense that. And his concern is also on account of contiguity, because for some projects you need land in contiguity. If you could carry on your project in small pockets, then nobody will need land acquisition. Land acquisition is needed only when contiguity is needed for a project, be it road, irrigation project or big industry. So without contiguity, there is no case for eminent domain, even for government. Government also, to provide public goods, government needs land, money, human capital also. But eminent domain is used only for land, not for human capital or other capital, because the contiguity requirement is there. All right, it was good to talk to you.
Thank you.
Yes.